The recording has started.
Chair Schmidt, do you want to introduce the meeting?
Please go ahead. I'll do the last part, but if you could go ahead with that.
All right.
Sure.
This is the Sunshine Ordinance Task Force Complaint Committee of the City and County of San Francisco. This is a remote regular meeting. To watch this meeting, you do bit.ly/3RUE D as in dog YE. Password is Sunshine. Public comment call-in number is 415-655-0001. Meeting ID is 2489-669-0328 ##. The date is November 15, 2022, and the time is 5:38. Remote access to information and participation. In accordance with Governor Newsom's Executive Order N3320, declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely and will allow remote public comment via teleconference. Members of the public may participate by phone or may submit their comments by email to sfgov@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Chair Schmidt, you want to read meeting decorum?
Yes, I will. Thank you, Cheryl. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and or menacing behavior may be asked to leave. And so let's go ahead and we'll start with number 1.
Item number 1, call to order, roll call, and agenda changes. Roll call. Member Wolf. Member Wolf not present. Member Stein.
Present.
Member Stein present. Chair Schmidt.
Present.
Chair Schmidt present. We have a quorum. Committee members, are you aware of any agenda changes?
I'm not.
No, nothing.
Yeah, I'm not aware of any either. Okay, so shall we move on to item number 2?
Yes, please.
Item number 2, approval of the October 18, 2022 Complaint Committee meeting minutes. I have a copy of the meeting minutes right here. If there are any suggested edits, be happy to take those.
Not from me.
I didn't have any either, Cheryl.
Okay, let me just mark that.
So I'll move to approve.
Okay, just a second, get my vote sheet out. Move to approve. Member Stein, are you seconding this?
Yes.
Member Stein, second. Okay. Hang on just a second. Mr. Young, do we have any public commenters? Since there is a motion.
If any members of the public who would like to make public comment at this time, you can raise your hand by pressing *3 or otherwise use the application to raise your hand at this time. I do not believe we have any callers in line for public comment. We do have Mr. Heckle with his hand raised, but I'm pretty sure he's not. That was raised prior to the meeting, so I don't believe he has public comment.
All right. Let's go for the vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Stein.
Aye.
Member Stein, aye. Member Wolf. Absent. Shall I call the next item, Chair Schmidt?
Yeah, let's move on to public comment.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Yes, if you'd like to make public comment, general public comment at this time, you can press *3 to raise your hand, or otherwise use the application to raise your hand at this time. We'll give it a few moments to see if anybody would like to make public comment. I see no hands raised. I do not believe there is any general public comment at this time.
Okay, let me just ask you to hang on a second. My document just did something. Okay, no general public comment. Okay. Right. Shall I call the next item, Chair Schmidt?
Yes, please.
Item number 4, file number 20111. Complaint filed by Anonymous against Mayor London Breed, Sean Ellsburn, and Hank Heckle in the office of the mayor for allegedly violating Administrative Code sections 6721 for failing to respond to a records request in a timely and or complete manner, 6726 by failing to keep withholding to a minimum, and 6727 for failing to provide justification for withholding, and 6734 for willful failure.
Okay, we will, in all of the complaint matters, we will allow up to 3 minutes from the petitioner first, and then 3 minutes from the respondent to give us a description of the case, to make your case to us. After that, the members will possibly ask questions, and then the members will confer after the question period to talk about whether to move the matter on to the task force. We'll be looking at issues of whether any documents or information involved are public, and does the task force have jurisdiction. We may make recommendations to the task force, and it's possibly take other action, but that's generally what we will be looking for. So at this point, I will call to see if the petitioner would like to speak to their case. We've already, of course, seen the documentation that's in the files. And when Cheryl's ready, we will start with up to 3 minutes from the petitioner.
Yes, if you are a party to this matter, you can go ahead and use the application to raise your hand so we can unmute your line and so you can speak. You can use the application, press *3. I have unmuted one caller.
Hello. This is Michael Petrellis calling. I only raised my hand to make sure you knew that I was on the call.
Okay, I'm going to go ahead and lower your hand at this time. You can go ahead and raise it again once we get to your item. So, are the parties to this item present for this matter at this time? Oh, I believe
We do have someone from the mayor's office, Hank Heckel.
Yes. Mr. Heckel, I believe I unmuted your line. Can you?
Yeah, I'm here. Good
Okay,
evening. Can you hear me?
thank you.
Second.
Anonymous, are you present at today's meeting? I'm just going to go ahead and unmute the other line. Maybe it's him.
Yeah.
Hello, caller. I just unmuted you. Oh, actually, that's probably Mr. Petrellis. I just unmuted a line. Is that anonymous or is that Mr. Petrellis? I'm not getting a response from that line at this time.
So we're looking for anonymous, but anonymous is not
Someone who
here.
just called in. Hello, caller. I've just unmuted you. I was just wondering if you're a party to this matter. Caller that I just unmuted, I was just wondering if you are part of this first complaint, anonymous versus the mayor's office. I'm not getting a response at this time.
All right, because I know anonymous is involved in this and the next matter. And representative of the mayor's office is present. It's not something that we see very often where anonymous does not appear for a case.
I
And
will say that it's been very tough to get on WebEx today.
has it? Okay, there's
Yeah.
Member Wolf. Member Wolf is now present.
Okay, Member Wolf, what time were you present so I can mark your participation?
I got here about 3 minutes ago.
All right, so let's just say you were here at 5:45.
Chair Schmidt, I'm just going to go ahead and leave the lines unmuted at this time, just in case they come back. And they can go ahead and just speak up and announce their presence.
Okay. If we're having a technical issue, I have some sense that maybe we could handle. Let me ask if the next petitioner is here. Maybe we could go out of order.
That's Ms. Schulman, and Ms. Schulman is not available until after 6 p.m.
6 o'clock. Okay.
Yes.
And then, all right.
Could I ask for a continuance, given that anonymous, the petitioner, is not here in the 2 complaints against the mayor's office? This is Hank Heckel from the mayor's office.
I'll ask my members. This is Chair Schmidt. I would be amenable to that. Yeah, members, should we just continue this matter?
Well, I would say it took me close to 20 minutes to get logged into this meeting. And it's very choppy. I had to turn off my video in order to be able to make it coherent. So I would say I would give it another maybe 10 minutes, 10 or 15 minutes to see if he shows, and then call it.
Okay, let's give a few minutes. There's a chance he's not going to be here, but because of the technical issue, Mr. Heckel, let's pass this matter for now and just check back. Let's go on to another case. I know Mr. Petrellis is present, and so let's hear the first of the Petrellis cases.
I believe, Mr. Petrellis, are you present?
Yes. Hello?
Okay, just one moment. We do have a representative for item number 9 present, but do we have a representative for item number 8 present? Okay. We have representatives from 8. I'm going to unmute them now. I believe that is the next item, if you want to call that.
Yeah, let's go. Let's do 8 first. That's the Mandelman office.
Yep, I'm Jackie Thornhill. I'm here from Supervisor Mandelman's office, but I think, was Michael supposed to go first?
Yes,
We
yes.
need to call the matter first, please.
Hi, I'm here. I hope you can hear me.
Yes, we can. Cheryl, can you call item number 8, please?
Yes, just a second. I'm trying to get my vote sheets right. Item number 8, file number 22119, complaint filed by Michael Petrellis against Supervisor Raphael Mandelman, Board of Supervisors, for allegedly violating Administrative Code Section 67.29-5 by failing to provide required calendars of certain officials in a timely and/or complete manner.
Okay, we will hear first up to 3 minutes from the petitioner, and then we'll do the same from the respondent side after that. And when Cheryl's ready, you can begin.
Mr. Petrellis, you'll have 3 minutes. Are you ready to begin?
Yes, I am.
Go ahead, sir.
Okay. Hi, this is Michael Petrellis, and I first want to say thank you for hearing my complaint. I filed a request with Supervisor Mandelman for his Prop G calendar, and I call the documents that I'm looking for, excuse me, the Prop G calendar because of the ballot measure that required the supervisors and others to keep a detailed calendar of meetings and other items that they needed to put on a calendar related to their official business. Now, with Supervisor Mandelman, my complaint has to do with the fact that he did not give me information about attendees at meetings and topics discussed. I cannot locate the documents right now about when he got me the information, though my recollection is that it was within 7 days after I had made the request. His office did get me a calendar that omitted who he met with and the topics discussed. So I think he was a few days late with getting me the information because the Prop G law says the public official has to give you all of the responsive records within 3 days after the meeting had occurred. So those are the issues of why I've made this complaint.
Thank you. Okay, when Cheryl's ready, 3 minutes, up to 3 minutes from the respondent.
Can I have your name, please?
Jackie Thornhill with Supervisor Raphael Mandelman's office.
Thornhill. Okay, great. Are you ready to begin? Go ahead, ma'am.
I don't think I have much to add beyond what was written in the supervisor's official response. I think that we likely would have had these requests were all pretty voluminous. They were generally for pretty large chunks of his calendar. Had they been for specific meetings, I think it's possible we would have been able to turn that around sooner. But I will say we've spent a considerable amount of staff time trying to comply with these. I've learned a lot about how Google Calendar works and how to export various things. And that while I completely acknowledge that not every attendee was listed, I think that the subjects of the meetings were overwhelmingly listed. Attendees were partially or completely listed for some. And I think that the records reflect that there was not a comprehensive effort made, but there was a good faith effort made. And we are also, as we noted in the letter, experiencing a significant amount of staff turnover, and we're working to better standardize our process for looking back on a weekly basis and adding all of the attendees to each meeting because we want to do better on that.
All right, thank you. Okay, members, do we have any questions for the parties?
This is Member Stein. I had a clarification question and then a question for, I guess both are really for the petitioner. But, what I see here is, first there are records that almost look like flowcharts in the first part of the first packet of documents around item 8, and then I see the much more detailed documents. And so am I correct that what you got at first was this kind of calendar flowchart document for the petitioner, and then what got submitted later was the office trying to fill in the details that were missing that second set of documents? Is that correct?
Yes, it is. And I looked over the first batch of responsive records and was surprised to see my name was listed for, I think, 4 meetings over the spring and summer. And I was like, oh my gosh, are they really having a meeting about me? What was it about? Who was there? So that is what led me to brush up on the Prop G law and then go back to Mandelman's office and say, hey, what about the attendees and topics for everything? And then they began the process to get me that information, which they have provided to me.
So in that second set of documents, you're satisfied with their completeness?
Yes.
Okay. And approximately how many days after your request did you get that second set of documents?
I'm going to say it was within 6 to 7 days.
Okay, so not the 3 days.
It was not a long. It was not a long period. I want to go on record saying that it was not within the 3 days, is my recollection. And Jackie can correct me if I'm wrong about that. But I would say it is certainly within 6 to 7 days.
Okay, thank you. Those were my questions.
Am I allowed to add something?
I'm willing. Yeah, definitely. I would like to hear from the respondent.
Oh, the only thing I would just add is that in the response, we listed the dates of every request we received and the dates that we responded. So if there are specific questions there were a lot of overlapping multiple requests. So all of those dates are listed in our official response.
Okay, thank you.
Any questions from Member Wolf? Okay.
Nothing to add.
All right. Just one question. Let me confirm from the petitioner. You believe that the final set of Prop G calendar information is still insufficient in both. It does not list all the parties to meetings or conferences, and it does not sufficiently set forth the substance of meetings. Is that correct?
No, that's not correct. If I'm understanding you correctly, you're asking if the records are insufficient with what's been provided to me since we clarified the need for attendees and topics. I have that information, and it does go back many months. So they have provided me with attendees and topics that were discussed in the second batch.
Okay, so it sounds like the issue that remains is the delay. Am I getting that right?
Yes.
Okay, so this is a delay case. All right, and okay, thank you.
But let me say that what was first released did not have attendees and topics. So there was a matter of insufficient information in the first batch released.
And so it appears to you that they had not been keeping the proper calendar, and then they only made changes based on your request. Is that what you think?
Yes.
Okay, got
Can
it.
Oh,
Yeah.
question when you're
I'm
done.
done. I'm
Oh,
done.
okay. Yeah, I just wonder, along that same line, I'm wondering if Ms. Thornhill can speak to how is Supervisor Mantelman keeping their calendar now?
Thank you. The one thing I will say is just that there is no difference in the actual data that was sent. We didn't go back and add anything. What we did was we discovered a way to do an export that included all of the details that we had not been previously aware of. And then I will say, as to how we're keeping his calendar now, we have a staff member who has that as a core function of their responsibilities, whereas it had been juggled among a larger number of responsibilities in the past. So that is a larger focus for the person who staffs on it. And we are having a weekly staff meeting where we go back and we look, what are the meetings from the past week that don't have attendees and subjects listed, and we go through and update those.
Okay,
And
so
I think
you're saying that you always did have
I think that we
originally you
made
had the names of all the attendees there, but you didn't know how to export them? Or are you
I think-
saying you don't normally follow that and you just check on a weekly basis to fill it in? Or
Sorry, let me try to clarify. We had been making a good faith effort, but we did not have a systematic way of going back and making sure that everything was in there. So for most meetings, there was a subject and there were some attendees, but there was not an internal process by which we verified that all of that information was there. So we are now doing that in a more systematic way.
okay, and so I'm sure you've reviewed the Prop G calendar requirements, and would you say that you now have a process to try to make sure that all the requisite information is included?
Yes, I would say that that's the case.
That's it from me.
Okay. No further questions from me. So at this point, the members will deliberate, and we do not decide the matter. We don't decide anything today because that would be something that the full task force would do. But we determine certain matters and decide how to send it to the task force. Any thoughts, members?
Well, this is Member Stein. I'll just say my thoughts are these are public records, clearly under our jurisdiction. I think this probably, is probably, a violation of 67.295 by a few days. So I don't know if we would want to send it to a consent calendar or if we would want to just send it for consideration to the full task force.
I would be more inclined not to put it on a consent calendar because I think that I'm sort of mixed about whether they may have satisfied the good faith requirement here. I don't see this as any kind of a severe case. I get a sense that maybe their initial submission was something that it should have been better, but they did have the information somewhere, and so they they weren't keeping the calendar maybe necessarily perfectly, but they did have all the information, and they did get it back together pretty quickly to respond to the request. So I think it's a question of fact that should be put before task force members. And I frankly don't know which way I'd go on that, because this is a standard to me that's different than some of these other violation cases where good faith doesn't help you.
Yeah. Yeah, I think a case can be made for that. I do have to say, in terms of all the Prop G calendars that we've seen, this is by far the most detailed in terms of what the meetings are actually about. So yeah, I understand what you're saying.
Agreed. Yeah, we definitely this is not one of the at all one of the extreme cases where they're just like don't even know the requirements there, or they're just not talking about what's in the meetings, and that's really, I think, where it's the big problems are. Yeah. Yeah, I would say, I'll just make a motion that we find, yes, this involves public records, we have jurisdiction, and we will forward the matter to the task force to determine whether there's a violation of 67.295.
I can second that.
Okay, so let's go ahead and have a vote.
Hang on. 29-5, is that what we had?
Public comment?
Yeah.
Yes, Cheryl.
I just want to confirm you. I heard 67.29-5.
Yes.
Okay.
So just get a head start. If there's anybody who'd like to make public comment on this matter, you can go ahead and raise your hand by hitting *3. And I would just go ahead and unmute our unknown callers just in case they're having issues. If you'd like to make public comment, if you can go ahead and announce yourself at this time, it would be appreciated. I do not hear any requests for public comment at this time.
Okay, let's vote.
Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Stein.
Aye.
Member Stein, aye. Member Wolf.
Aye.
Member Wolf, aye. Moved by Chair Schmidt, seconded by Member Stein, to find that these are public records, there is jurisdiction, and to forward the matter to the task force with a recommendation for a violation of 67.29-5.
Okay, I'm gonna announce just to see if we have either anonymous or Ms. Shulman present. Could you just give us a verbal indication?
Okay, Ms. Schumann just logged in just a moment ago. However, everybody else is unmuted, and they can announce themselves. If Anonymous is here for the first two items, if you can go ahead and announce yourself, it would be appreciated. All lines are unmuted.
I'm on the line from DPA. This is Sarah Maunder.
Okay, thank you
This
for
is Hank.
We are
from
looking for Anonymous for our first two items on today's agenda.
Hi, this is Hank Heckle from the mayor's office.
Mr. Heckle is here from the mayor's office for item 4 and 5, but Anonymous does not appear to be here.
Okay, we don't have anonymous here.
Call it. Let's call it.
Let's, I would grant Mr. Heckle's request to continue both matters. Let's just, I mean, we can say we'll continue let's see, what number is it? Number 4, and then we'll call number 5 just for official purposes, but let's continue. I move to continue number 4.
I have a question. Do we want to continue it, or do we want to close it and under complaint procedure section 7B and allow the petitioner 60 days to get in touch with me to reopen his case?
Well, I like the continuance better myself because it was requested, and I feel like we're going to hear from Anonymous about this anyways.
Yeah, I just checked my notification, and I did send him an invitation, and I sent him the link to the agenda packet. So,
okay, members, do you have any thoughts? Cheryl suggested a different solution.
I think I'm in favor of a continuance in this case because Anonymous is a fairly active petitioner, and I don't think this is going to be dropped, probably.
Okay. So, yeah. All right. So, will you second my motion then?
Yes, I
Okay.
second.
okay, so let's see. Dean.
Thank you for the suggestion, though, Cheryl. But we're gonna see if we can do it that way.
Okay, and continue items 4 until 5 until when? December? Next month?
Yeah.
Okay, so do we want to take public comment? Did we
Time for public comment.
Okay, if there's anybody who'd like to make public comment on the continuance of item 4 and 5, you can go ahead and announce yourself. It would be appreciated. I do have someone notice Mitch Manikin, who is announcing themselves. Would you like to make public comment at this time? You should be able to, all lines are unmuted, so you should be able to just speak at this time. Oh, my apologies. I have multiple things going on my computer. I may be seeing the Board of Supervisors meeting announcing themselves and not this meeting. My apologies for that.
You're forgiven.
We appreciate your multitasking ability.
I do not see any public comment at this time.
none. So we want to take a vote on items 4 and 5?
Yeah, that's fine.
Let me find my vote sheet. Okay, we're taking a vote. Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Stein.
Aye.
Member Stein, aye. Member Wolf.
Aye.
Member Wolf, aye. Moved by Chair Schmidt, seconded by Member Stein to continue items 4 and 5 until the December Complaint Committee hearing.
Okay, let's do the first Showman case now.
Okay.
Okay, give me one moment.
2.
I have unmuted Ms. Showman.
Hi, can you hear me?
Yes.
Okay,
Yes.
good.
Yes.
Is there a representative from Animal Care and Control present at this time?
I heard from Animal Care and Control last week. They indicated to me, and I believe I sent those emails to Chair Schmidt, that nobody from Animal Care and Control, because it's a small department, would be available to speak on their behalf. People are on vacation, one's on maternity leave, one is in a meeting that she is required to participate in, that's at the same time this meeting is. There was just nobody available.
Got it. Yeah. Yeah. I saw that. Well, I think we'll just hear the matter without their
The respondents.
Speaking to it, and decide whether to have it go to the full task force.
Okay, so we are having Ms. Schulman.
Yes. So the first thing we'll do, I've already said, but I want to say it just because it's a new hearing. I know Ms. Schulman, but we've only met a couple of times, but I just want to put that on the record. She's a friend of a friend, but I've explained it before. And so the first thing we'll do is up to 3 minutes from Ms. Schulman to tell us about the case, with the caveat that we've all read the documents that are in the record. So we already understand, I think, what the issues are. So when Cheryl's ready.
Ms. Schulman, are you ready to begin?
Yes.
Go ahead, ma'am.
So thanks to the complaint committee for taking the time to hear my complaint today. As you can see from the documents, I filed the complaint on November 12th of 2021, and I filed the complaint because the respondent was withholding one of the records that I requested. And I had already followed up twice with the respondent on November 8th and on November 12th of that year, reiterating my request for this particular record, and the respondent had withheld it and refused to provide it. And after I filed the Sunshine complaint, the record was finally released to me a few days later on November 15th, 2021. The respondent claimed that they were withholding that record because of attorney-client privilege, but it's plain that attorney-client privilege does not apply to this particular record because it had already been shared with multiple third parties prior to my requesting it. And the respondent did not even bother to consult with the city attorney's office about their decision to withhold the document until after I filed my complaint. And the city attorney's office judged that the document in question was not, in fact, exempt from disclosure. And it should not take multiple requests and for me to file a Sunshine complaint before a city agency agrees to provide all the records that I've requested. The respondent should not have attempted to withhold this record under false or inaccurate pretenses, and the respondent should have immediately consulted with the city attorney's office before inappropriately citing attorney-client privilege. And this is, to me, so clearly not an instance of attorney-client privilege that it just makes me question the respondent's motives for withholding this particular record, especially since I am mentioned in the record by name in a derogatory way. I believe that the respondent attempted to withhold this record from me out of personal bias. And that's all I'll say about that. I'm happy to answer more questions.
Great, thank you. All right. Actually, that I had a series of questions, but your description just now probably answered all of them. In your description of the case, thank you for that, because now I understand what it is precisely, in that you, after seeing the document that had been withheld and the substance of it, you're contesting their decision not to give it to you initially and to assert that privilege. Okay. So at this point, do any the members have questions for Ms. Schulman? And again, it doesn't look like we have any questions. Could you tell me, Ms. Schulman, I don't know if you have the record with the same pagination that we have, but I wasn't quite clear if we have that one page in our file. I looked for it and I just either I missed it or it's not there. And the date that the document was that's on the document.
Sorry, the date that that what?
The letter in dispute that was withheld initially. What was the date of that letter?
So, well, the actual letter that was withheld, it's an email. And if you look, the packet that's included on that's linked on the agenda to this meeting, it starts on page 11 and it goes to page 12. Are you asking about the date that document was written, or are you asking about the date that it was given to me?
Okay. If I see what you're looking at as 11 and 12, I'm trying to follow you. Okay, here we go. So 11 and 12.
It's P321.
Is it the October 13 letter?
Yes,
yeah. Okay. Okay.
Yeah, that's
okay.
it.
That's the one. Okay. And is this how it was produced to you when you eventually got it?
I think so.
Okay.
Yeah.
Signed by Claire O'Hoyne. And you said, oh, I see you're mentioned in here also.
Yeah.
Okay.
Yeah, it's mostly about somebody else, but I mentioned in there.
Sure.
And
okay.
The reason that I think it's not attorney-client privilege is like not just based on the contents of the actual record, that email, but if you look on page 14 of this packet, it says memos for animal number A3, et cetera, at the top. They talk about this document in the text of that, in these memos. If you look down at the bottom of that same page, page 14, the person who wrote the email is, it says she gave us a copy of her email to her attorney stating that, so the person who wrote the email handed the animal control officer a copy of the email to her attorney. And then that animal care and control officer attached that document to the VD inspection page and also put it in someone else's mailbox. Okay. So it's been shared more than once.
So your argument
before I even
your argument will be that if it had been privileged, that privilege was waived by what's called sort of excessive disclosure, that it went outside of the privilege circle. Okay, got it. Mm-hmm. Okay, I think I get it. And yeah, that's all the questions I have. So members, I think there definitely is there's a decent argument in what I'm seeing that this was waived, if there even was privilege to begin with. Although both, I think that there may be something that I don't know, but the indications are that it may possibly have been privileged by looking at the people who are listed on the email, although there are some CCs.
Yeah,
we don't know who those people are, so it may have been initially not attorney-client privilege just for that reason. And then in that, and thank you, Ms. Shulman, that notation to the to the further dissemination, that's important too. That's the issues that I see in the case. And yeah, there may have been a violation here. So I think that there's certainly it should be put before the full task force to be looking at whether there's a violation.
Well, here's what I'm wondering. This is Member Stein. Is
yeah.
You know, Ms. Schulman asks us to look at whether there's a violation of 67.21, which is, you know, on the basis that, you know, the complete records weren't provided in a timely manner. But they are provided within 17 days of the request. And this was during the mayor's proclamation, which seems to have been rescinded on the same day that this record was released. Is actually November 15th, 2021 is when the mayor's proclamation was rescinded. So I'm wondering, is this really a violation of timely manner when the sunshine, well, you know, I don't know if it meets the CPRA standards for timely, or is this something to do with improper withholding or improper justification for withholding only?
I take what you're saying. I think, thank you for looking at it in the light of the changes in the COVID related law. Yeah, it may be that the delay issue is affected by that. Although the second part of what you just said, Member Stein, that it does seem like the initial withholding was on an improper basis. And so I think that because it was provided, and then I believe Ms. Shulman had to go to them and say, I want that. And she had to contest their designation of it as attorney-client privilege. I think that's where maybe there's a violation.
Yeah, I'm trying to remember what I saw here. So basically, they just didn't give it, and then she followed up. So they didn't even justify why they didn't give it. They just didn't give it. But
Ms. Shulman, so they initially told you it was attorney-client privilege, and then you went back to them to question them about.
Yeah, I went back and said it's not attorney-client privilege. Well, yeah, at first they just didn't give it to me. Wait, let me make sure that's true. Somewhere in this packet is the records request on next request, and it has our conversation back and forth about the documents. Where is it? Sorry, let me see if I can find it. I mean, yeah, at first they said, we think here are the records that we have, but we have to talk to the rest of our staff and get more. And then at a certain point that they said it was attorney-client privilege, and I said, no, it's not. And then they went to the city attorney's office. I think it's page 3031. Yeah, so page starting on the next request.
it does. I see it.
Is on page 28, and then it goes down.
It just says one record has been withheld on the basis of attorney-client privilege at the bottom of page 30. Right?
Yeah. Yeah, and so I asked for it, like if you go to page 31, I said, please provide the email referenced in the memo. Yeah, at first they just didn't give it to me, and then they said attorney-client privilege.
When they eventually told you they were going to give it to you because they decided after going to the city attorney that they were going to produce it, did they say to you that they had decided that it never was privileged, or that there was a waiver, or did they
No.
just give it to you and not go into the detail on that?
Yeah, they just gave it to me. So I think all of our talk about it is here in this next request portal thing. And yeah, on page 29, at the bottom of page 29, they just say, after guidance from the city attorney's office, we were given clearance to provide the letter here. It has been redacted on the basis of personal privacy. And before that, I had already filed the complaint with the Sunshine Task Force at that point. And on page 30, kind of in the middle of the page, I explain why I don't think that it's attorney-client privilege. I say the email referenced in the memo was included in the property inspection report and is part of the record for this animal. And the animal owner is quoted as saying that she wants to have this quote on record. As such, the email is public record. So yeah, I guess I meant to say it's not so much the timeliness of them with this request. It's the fact that they tried to withhold this record from me and cited attorney-client privilege, and it just doesn't make sense to me that this would be attorney-client privilege, because Animal Care and Control is not acting as the attorney for this individual.
Yeah, you had to come to us in order to get them to produce this document.
Right.
Okay, got it. Yeah, okay. Thank you for that clarification. I have nothing further. No questions. Member Stein, does that resolve any?
Yeah, I mean, I want to look up what is the section for improper withholding.
Mhm.
I have a question.
Yeah.
Sure. Member Wolf.
So this is kind of a general question. Can a respondent declare attorney-client privilege without describing why they're declaring the privilege? For instance, that it would reveal personal information, or it would reveal certain details about an investigation, or anything like that. Can a declaration of attorney-client privilege without proving such be declared?
I can give you my answer to that, which is the content doesn't matter. It's the fact that it is communicated between the parties who are represented by the legal counsel and the legal counsel, or somebody acting on the behalf of one or the other. If there is a communication, then the content itself, you cannot immunize facts by putting it into the communication. You can't say, well, because I told them that, now those facts are privileged. But the fact that the full content of what was conveyed by the client to the attorney, or vice versa, that conversation, that communication, you just have to say attorney-client privileged.
Okay, so my next question is, isn't attorney-client privilege a privilege meant for the attorney?
The client is the owner of the privilege. The work product is the one that is held by the attorney.
Can I just say, I'm looking at this, and I think this falls for me under a violation of 67.26, withholding kept to a minimum, potentially, because the office, the response was not, we need more time to see if this is a document that we cannot release because of attorney-client privilege. They simply state that we're not giving this document because of attorney-client privilege. And it doesn't appear that there's no information about this being sent to an attorney, to the city attorney's office to determine this. It's just a statement that we've decided that we're withholding this because of attorney-client privilege. And then it seems that the decision or the consultation, if there was one, they don't even tell us that there was one, to release this document happens after there's a complaint. So to me, because the timing, kind of isn't as critical within the falling under the period where the mayor's proclamation was in effect, I think the more critical issue is that withholding was not kept to a minimum, and a reason for withholding was given that was not a vetted reason.
The one point that you just made that I would I would disagree on is that if it turns out that the document is truly protected by the privilege, you don't have to say that you consulted with the city attorney. You don't have to, demonstrate that you got approval from your lawyer to withhold a document. It really comes down to just what's in the document. And even if they did go to the city attorney and the city attorney said it's not privileged, that it's privileged, but say we ended up seeing it and we say it's not privileged, just the fact that the city attorney has the opinion that a document is a privilege would not bind, to me, it wouldn't bind us, or would it bind a court? So I agree that they should have gone to the city attorney to find out if it's privileged. Although, if you look at the document, there are indications that it may have been intended to be privileged because it was sent from an involved party to a few lawyers. And so it looks like they were trying to communicate in the way that a client would communicate with lawyers. So I can sort of see why they may have thought, oh, that might be privileged. We better handle that differently in some way.
But if something is attorney-client privilege and you share it with people who are not your attorney, isn't that the end of the privilege?
If it is disclosed outside of the attorney-client relationship, and I'll just I'll just use the simple example, which is one client, one lawyer. If they have a communication and then that's disclosed outside of, say, a judge that demands it, or an expert witness that that's within the privilege, if it is disclosed outside, then the document itself, the privilege has been waived. And so it is available to others. Yes.
Isn't disclosing it to a public agency?
Pardon me?
So would disclosing it to a public agency be considered disclosing it outside of, that attorney-client relationship?
Well, it can be sometimes a pretty complicated question. If it's among people within the agency who are involved in a legal dispute, then there may be certain communications amongst them, say they're co-defendants, and that could still be privileged. But you go outside of that type of scenario and you start sending it to other departments, etc., you're probably going to lose the privilege. But to me, I'd hold off on trying to make a global statement about that and just say that that's where you get, like, it depends on the facts. But generally, you have to keep it close within whoever's considered the attorney or the attorney's representative, and then on the other side, the client and the client's representative, if they have, someone who's within the scope of the privilege.
Mr. Chair?
Okay.
Yes.
But the privilege, the attorney-client, like, confidentiality still remains with the attorney not to reveal the confidential or protected information. Is that correct? It would be the client's choice to reveal it.
Yeah, the client has the ultimate choice, and the client can require the attorney to, keep documents privileged, or the client could request that the attorney disclose, or the client themselves could disclose. But the attorney needs to, if it's something held by the attorney's obligated to not disclose it because of the privilege, and the client has the right to not disclose it based on the same privilege.
Okay, thank you.
Sure. Now, there's attorney-client privilege 101. So, yeah, I think that my thought is there's enough here to send it. We may have a timing violation. I think we do, partly because she had to file a complaint after she got what she thought was going to be the full package. And so I think that's a question of fact that should go before the full task force. And then, improper withholding seems to me to be, if that's a separate violation, I think that's really what was improper here, was that well, I'm not even sure if I'd have to look at it to be in sort of like trying to decide for myself, because I'd want to know from the other side, if they show up before the task force, okay, who are these people who are listed, who it was disclosed to? Why do you think it was still within the privilege, et cetera, et cetera? But we don't have them here, but they have the right to be there later.
But even then, it's just trying to understand why they thought it was privileged.
Exactly.
When ultimately it was determined that it was not privileged. So
well, we haven't. Nobody's determined that.
Oh, no. I thought it was, because that was the basis of it being released.
No, that's a good question though, because it's my understanding from what Ms. Shulman said is that they didn't tell her anything except we're now going to give it to you. But they didn't say we have decided we're going to give it to you because it was never privileged. They didn't tell her we're going to give it to you because we realized we waived the privilege. They may have made the decision to give her a document that they thought was still privileged, but they were deciding by handing it over, they were going to thereby do the waiver by that act. So I think part of what, the ultimate decision at the task force is, in this case, for example, is to look at this thing and decide, do we think that this document, when it was withheld, at the point when it was withheld, was it covered by the privilege, and or was it that privilege waived?
Yeah, I'd have to agree with that. But I mean, I think finding jurisdiction is not an issue. I mean, the question of whether the record is public or not, whether it's attorney-client privilege or not, it's a record of the department, and it's should be deemed public.
Is that the start of a motion?
Yeah, I guess so. So I'll move to find that the records are public, and that the complaint be heard by the task force. Unless somebody wants to add some other detail for it.
Who's seconding?
I'll second it. This is Member Stein.
Yeah, we're going to send it to the task force, basically. Okay, let's have a vote.
Public comment.
All mics are unmuted except for one person, but she's not associated with this matter. So if you'd like to make public comment, go ahead and speak up at this time. My apologies, I kind of lost my speaker for a moment. I didn't hear anything. So I believe we can close public comment at this time.
Okay, let's vote.
Member Wolf.
Aye.
Member Wolf, aye. Member Stein.
Aye.
Member Stein, aye. Chair Schmidt.
Aye.
Chair Schmidt, aye. Moved by Member Wolf, seconded by Member Stein to find that the records are public. There is jurisdiction that the complaint be forwarded to the task force for hearing.
Okay, let's go ahead and hear the next case involving Maria Shulman.
Okay. Item number 7, file number 22070, complaint filed by Maria Shulman against Sarah Maunder and the Department of Police Accountability for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and complete manner.
I have an initial question, and I did hear that Sarah Maunder is here, so we have the parties here. There seems to be a question of whether the 22070 has similarity to 22077. And I wonder if anyone could say what the status of 22077 is. And that would include Ms. Shulman. If I just want to know if we've already heard something that might be the same case.
I'm sorry, could you repeat that number, please, Chair Schmidt?
70 versus 77, 22070, 22077.
Yeah, I think we haven't heard 77 yet.
No, we have not.
Okay. Ms. Shulman, do you believe that those cases should be heard separately?
I do.
Okay.
And I think
did they involve
I
the
can
same
explain.
the same file, the same file with the same file number?
Yeah, I requested the same file in both of those records requests, but I worded this one that we're about to talk about differently, and I thought I worded it more specifically.
Okay, okay. At some point, Cheryl, could you make a note that it does sound like at any future time we should handle the two cases at the same time, it consecutively, at least, since they involve the same files.
Okay, just a point of clarity. I actually posed that question to Ms. Schulman, and she said she needed time to prepare. So I did ask her.
Oh, okay. Well, we could go ahead with 22070 today.
Yeah, I mean, I'm ready. Ms. Schulman, are you prepared to do
Yeah.
item 7? Okay, that's what I thought.
And then I guess we probably should make sure that 77 comes up before us, so someone else isn't sort of reviewing for the same things, just like we are here. And then after that, they should go together to any calendars, like when they go to the full task force.
Yeah.
Okay, let's go ahead with 22. Let's hear 70.
Okay, just before we do that, are you requesting that this other case be heard by the complaint committee in December? Is that something you want? No.
I don't want to change the order that you have. I don't know what your order is, but I'm not making any like expedite type of request. I'm just saying that it would make no sense to have one of them heard and then somehow 6 months later the other one shows up, and it does sound like it's possibly just about the same case. I'm not trying to disagree with Ms. Schulman that she believes that there are differences. I'm just saying that we can handle them much more efficiently if they're bundled.
Okay, I understand what you're saying. My thought was if we have the second complaint against police accountability in December, perhaps in January, we could schedule both those cases and then they can be combined, or whatever the committee decides to do or the task force decides to do. And then we can sort of eliminate any issues.
Okay.
Mr. Chair.
Yeah.
So my concern about this is now that I agree with you in your premise, because otherwise this pushes both cases out another 2 months. And I just think with respect to efficiency and expediency, I think both these items should have been on today's agenda so we can determine that whether they should be combined or not. I'm wondering if for our next meeting, well, it'll be after the task force meeting in December. So I'm wondering if for the sake of expediency, whether we might not refer this to another committee and have them hear both items, and then they make a determination whether to combine them, so it can be determined whether it could be put on a December task force agenda or not, if that hasn't already been decided.
Member Wolf, there are no committee meetings after this one for this month.
Okay.
That's what I was suggesting.
The sum of it, I think, is that let's just make sure that, I'm sure we'll hear 77 somewhere where when its turn comes up. And but when they go to the full task force, these two cases seem like they're so factually similar that they should be handled on the same day. But that's all I'm going to say about that. All I want to do is at this point, let's go ahead and hear 22070. I see the merit of Member Wolf's suggestion, and I would be somewhat inclined to go with that idea, though then hearing that there isn't actually a upcoming committee hearing, let's just go ahead and if we can do 77 in December, let's do 77 in December if its turn is coming up. And I know that number is close. Okay. So when you're ready, Cheryl, first we'll hear from Ms. Shulman to introduce the case. Up to 3 minutes.
Ms. Shulman, are you ready to begin?
Yes.
Go ahead.
Okay, so thanks again for taking the time to hear this complaint. So I filed this records request in June of this year, and I received a response from DPA basically saying that police officer personnel records are exempt from disclosure. But my request was not just for the file of this complaint against the police officer. It was also for, quote, all written records, including emails related to this complaint. And I would not expect those emails that like reference the complaint to be part of any police officer's personnel file. What I wanted DPA to do was to search their emails and look for that file number and give me the emails that contain that file number. And I don't believe that all of those emails would be in the personnel file. Also, in a separate communication with the chief of staff of DPA, I was told that the file that I specified in my request had been transferred to another city agency before any kind of personnel investigation had been begun against the police officer. So even if the actual file is exempt from disclosure, I would still like the DPA to at least partially comply with my request by giving me the written correspondence, including all emails that they have regarding this file. And I would also like them to confirm whether or not the personnel file even exists in their archives, because the chief of staff gave me to understand that there was no file for me to have. Thank you.
Thank you. And when Cheryl's ready, we'll hear next from Ms. Monder.
Ms. Monder, you ready to begin?
Yes.
Go ahead.
Okay, so DPA does not contest that you have jurisdiction over this complaint. I do want to revisit the topic, though, of the two complaints filed over the same matter, because I think it's really important. This matter that we're hearing right now, 22070, requests the complete contents of an investigation into a police officer's allegations of misconduct, and the exact same complaint was filed earlier in June, on June 3rd, 2022, and that's 22077. That is about all records pertaining to the same investigation. So essentially the first complaint, task matter, Sunshine Task Force matter, is about the requester wanted everything related to that investigation. And then she submitted a second reworded complaint saying she wanted everything, including but not limited to emails type of thing. So I do think these are the same complaints, but again, we're not contesting jurisdiction.
Is that it, ma'am?
Oh, yeah.
Okay, thank you.
I'm sorry, I was muted. Question for Ms. Shulman. The identity of the officer who this complaint file would be about, I don't need to hear the name, but is that something that is within your knowledge who that is?
Yeah.
Okay. Do you believe that the file that's not being produced would contain your name?
Yes.
Okay. What do you know about the circumstances of that that DPA action that has the number that is set forth in your request?
So, I filed this complaint against the police officer, and then there was a lot of like back and forth with DPA about it, and I believe that there are a number of people at DPA who they don't have the file, but they have the file number, and there's a bunch of emails that contain the file number that exist.
Okay, so you were the complainant
Yeah.
against the officer. Were there ever any proceedings taken against that officer?
No. I was told by DPA that they decided to transfer the complaint to another agency. And
did they tell you who?
Yeah. And yeah, and so that it's proceeding with this other agency. But I was given to understand that they're like, I don't know if DPA has the file or not, and I would like them to tell me whether or not the file exists instead of giving me this like kind of cookie cutter answer.
Okay, so they said to you at some point when you filed a complaint, they said they assigned a number to it, and I'm guessing that the next thing you heard was that they said, we're going to transfer this to someone else. But nothing, they never interviewed you. You don't know if they did anything within DPA. Is that fair to say?
Yeah,
okay.
that's correct. And in fact, I was told that they specifically did not interview, like they intentionally did not investigate it.
Okay. So you felt like, is it fair to say you felt like pretty early on it got shipped out to someone else?
Right.
Okay. Do you think that there even is a file per se, other than like a manila folder that's empty? Do you have any sense that there's anything other than emails?
No, yeah, I think it's yeah, I don't have a sense that there's anything.
Okay. Okay. And the emails themselves that you believe DPA would have sent to other people about this complaint you had filed, that's something that you believe you should have been given, correct?
Correct.
Okay. Okay, got it. Question for Ms. Maunder. Can you tell us, was this case, was this a case where Ms. Shulman filed a complaint with the DPA and the DPA transferred it to another department in the city?
Yes, that's correct. Ms. Shulman was the complainant, and we did a preliminary investigation and then transferred the case to a different city agency.
Okay, okay. And when that kind of thing happens, would there be a physical when I say physical, it doesn't necessarily mean paper, but a file, either electronic or physical, where you just take the whole thing and you just convey it over to those other people and you don't even keep a copy? Is that something that could happen in this circumstance?
No, we would always retain our initial investigative file. So whenever a complaint comes in, we begin an investigation, and usually the first part is to determine if we have jurisdiction, what the allegations might be. So that investigative file will remain with us. And then when a referral occurs, we basically alert another city agency that allegations have been made, and that then they can initiate their own investigation. And depending on who it's referred to, we sometimes are able to share our preliminary investigation with that agency, and sometimes not.
Okay, okay. And let's see. I was going to just ask you one more thing, which is, are there emails such as the ones that Ms. Shulman is describing, where your department may have sent communications about this to other departments? Are those within what is withheld in response to her request?
Yes. Any emails sent in connection with the case would have been done for an investigative purpose and are part of the peace officer's personnel file and would be withheld.
Okay, got it. Okay. No further questions. Members, any other questions? Okay, I guess we ought to figure out what we want to do with this. I personally, I think that I'd have to think on the emails question, because I don't know, just sitting here without doing some research, whether something like that would seem to come within the exemption, the peace officer personnel file exemption. In other words, I think that could go either way as we sit here today, but we're not deciding, so I don't feel a need to get any further clarification from my own thought process. I mean, I think that it's possible that, because we do know that there were emails and they were requested. Ms. Shulman says she should have gotten them, and Ms. Maunder says they were sent for investigative purposes. That That may or may not be. I just don't know if I'm set to opine on that in any way, but we're not making any decisions. So I think we should send it to the full task force to decide whether it might be that this whole file is exempt and then there was no violation. That's a possible, but also it could be that there were some things that should have been disclosed.
Just to clarify, there are emails probably sent like by DPA employees to each other, to other departments that reference this case number. But I'm also aware of at least one email that was sent from by a private citizen who had the case number who wanted to follow up. And
yeah.
So yeah, that I think also should have been disclosed.
Okay, thank you, Ms. Schulman. These exemptions sometimes are pretty powerful, and they can kind of wrap up entire parts of a file. So I just don't know as we sit here today if those would come within the exemption, but it may be that they don't. But I do think that we should have the full task force make a call. And so I'm willing to make a motion unless the other members wish to advance this thing.
I'm happy for you to make it. I'm hoping it will include that we're raising the question of what is necessarily included in personnel records, and whether emails discussing a file number or mentioning a file number would be considered a personnel record.
Agreed.
Yeah.
So it hones it in for the task force.
Good idea. I like it. Very, very good. Okay, I'll move to find, we have jurisdiction. The records, they're held publicly, though there is an exemption that's claimed. We move it to the task force to find if there is a violation for failure to disclose publicly available segments of the files held by DPA, and to consider the proper scope of the peace officer employment exemption as it applies to emails across city departments.
And Laura, you said you were going to second this? Member Stein?
I don't think I said, but I can second it, yes.
Shall I read it back, Chair Schmidt?
Yes, please. Yeah, see if it made any sense.
Yeah. Moved by Chair Schmidt, seconded by Member Stein, to find there is jurisdiction. The records are held publicly, though there is an exemption claimed, and to send to the task force for failure to disclose publicly available segments of files held by DPA, and consider the proper scope of the peace officer employment exemption as it applies to emails across city departments.
That sounds great. Thank you. Thank you, Cheryl, for catching all that.
Okay, so we want public comment?
Yes, please.
Sorry, muting again. Everyone is unmuted at this time. Is there anyone who wants to make public comment? They can. Just go ahead and announce yourself if you'd like to. I believe we can close public comment at this time.
Okay, let's vote.
Chair Schmidt.
Aye.
Chair Schmidt, aye. Member Stein.
Aye.
Member Stein, aye. Member Wolf.
Aye.
Member Wolf, aye. Shall I read it back a second time?
No need.
All right. Thank you, Ms. Schulman, for participating.
Thank
Yeah,
you.
thank you to the parties.
Okay, so now we want to hear item number 9. Am I correct, Chair Schmidt? Mr. Petrellis, his last item?
Yes, that is correct.
Okay, just a second. People work together. Okay. Item number 9, file number 22126, complaint filed by Michael Petrellis against President Shaman Walton, Board of Supervisors, for allegedly violating Administrative Code Section 67.29-5 by failing to provide required calendars of certain officials in a timely and/or complete manner.
Do we have a representative here for the Shaman Walton office?
We have Ms. G. You have control over your own microphone. You are a panelist.
Yes, thank you. I am here. Is Mr. Petrellis presenting first?
Yes, yes. Yeah, we'll hear first from Mr. Petrellis, and then you will follow. 3 minutes, up to 3 minutes each.
Mr. Petrellis, you ready to begin speaking?
Just 1 second. Hi. Yes, I'm now ready.
You may begin.
Hi, Michael Petrellis again. I submitted a public records request to the president of the Board of Supervisors for his Prop G calendar, and I thought he would understand that I was referring to the calendar that is required to be kept by him because of the ballot prop a few years ago. And the first response from his office said that they had no records responsive to my request. And eventually, I sent an email to them that clarified what I was referring to. I'm looking at page 17 of the 134-page document that you shared with the members, and the response from Walton's office lays out the timeline here, that I made the request in October, and they didn't understand the reference to the Prop G calendar. They eventually said that they thought I was referring to this year's Proposition G on the ballot, and that is why they didn't give me any records. And I am arguing before the task force that ignorance on the part of the board president is inexcusable. He should be setting an example of keeping and releasing a Prop G calendar. And there should be no burden upon me to clarify what a Prop G calendar is. He was just reelected. He's been on the board for 4 years, and the level of ignorance is quite stunning. I would hope that he would set an example here in terms of keeping the calendar and releasing it. The letter from his chief of staff It says that they would turn over the records by Tuesday, November 8th, and I am arguing that they were late in releasing the records, and that ignorance is no reason for that tardiness.
Thank you. Okay, Cheryl, when you're ready, we'll hear from Ms. G.
Okay, just a second. Ms. G, are you ready to begin?
I am ready.
Go ahead.
All right, good evening, Sunshine Ordinance Task Force members, and thank you for taking the time to hear this item tonight. On October 17th, 2022, 8:52 a.m., Mr. Michael Petrellis sent the following directly to President Walton's email. Quote, "To whom it may concern, this is a public records request for an electronic copy of your Prop G calendar from January 1st, 2022 through October 15th, 2022. If you have any questions, do not hesitate to contact me. Please confirm receipt of this letter at your earliest convenience," end quote. On Monday, October 17th, 2022 at 5:28 p.m., I responded on behalf of Supervisor Walton that he did not have any records pertaining to Mr. Petrellis's request specifically for the, quote, Prop G calendar, end quote. At the time, we were under the impression that Mr. Petrellis was requesting calendar entries related to Prop G, also known as the Student Success Fund, that was on the November ballot, especially with the general election coming up, which Supervisor Walton did not have. On subsequent follow-ups on November 1st, 2022, it was clarified that Mr. Petrellis was referring to Prop G that was passed in 1999, 23 years ago, that requires officials to maintain a daily calendar reflecting their meetings. In our office, the supervisor's calendar is generally referred to as calendar or daily calendar and not Prop G calendar. Had Mr. Petrellis asked us for the calendar, we would have sent the records in sooner. Upon that clarification, I notified Mr. Petrellis and Ms. Lager that on November 2nd at 4:19 p.m. that we would provide the records by the end of the business day on Tuesday, November 8th, 2022. The records of Supervisor Walton's calendar from January 1st to October 15th, 2022 were sent to Mr. Petrellis on Tuesday, November 8th, 2022 at 4:59 p.m. with Ms. Lager copied. And that is all I have. Thank you.
Thank you. All right, members, I don't think I have any questions. This one looks pretty straightforward. Anything?
See. So the calendar was complete, like all the records were completely produced by November 8th. Is that correct? That's my question for the petitioner.
Yes, correct.
Okay. All right. That was my only question.
Okay. Unless Member Wolf has any questions.
I have a question for the respondent. I'm a little confused by your depiction about the calendar. Has anyone described a calendar to you as Prop G calendar before?
Member Wolf, no one has asked for specifically a Prop G calendar. When people have Sunshine Dust in the past, they've asked for calendar or daily calendar, and we have produced those entries.
And so, are you being? I'm just curious. Do you think the Prop G calendar is something different?
So, in when we received that email, we were in the mindset of there's an election coming up. So that's what we thought the calendar was referring to. But upon further clarification, we did provide the actual records.
Okay. And did you maybe, okay, so you understood what Mr. Petrellis was asking for?
Yes, only upon further clarification on November 1st.
And who provided you the clarification?
I believe Ms. Lager sent us an email, and then the city attorney for the Board of Supervisors sent out an email to everybody.
Okay, great. Thank you very much. So I have.
Okay, no more questions, I don't think, from anyone. So let's figure out if we're gonna, what to do with this. I think it may just be what you feel about, I think it may be this good faith standard that applies. And I don't think there's a lot of factual discrepancies here. I'm inclined to think that somebody thought that for whatever reason, they thought that maybe someone was looking into this year's Proposition G. I could see that as a reasonable thought, a reasonable impression. I don't know if it, I mean, it is it's plausible to me. So I could see going either way on this. And so I say we send it to the task force to determine. I don't know if I'd want to make any kind of recommendation.
I agree with you on that and would support a motion.
Okay.
Member Wolf, you're second, and Chair Schmidt, you are moving.
Yeah, just send it to the task force. We find that they're public records and we find we have jurisdiction.
With the recommendation to find no violations?
No recommendation whatsoever.
Okay.
Just don't even, yeah, no recommendation language.
Okay, so we want to go for public comment?
Yes.
Okay, again, all mics are unmuted. We do have Ms. Schumann on the line who is muted. If you'd like to make public comment, please raise your hand by raising your hand using the application at this time. Ms. Schumann has not raised her hand. I don't believe there's any additional public comment for this matter.
Okay, let's vote.
Chair Schmidt?
Aye.
Chair Schmidt, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Stein?
Aye.
Member Stein, aye. Moved by Chair Schmidt, seconded by Member Stein to find that the records are public. There is jurisdiction and to forward the matter to the task force. Chair Schmidt, I believe that takes care of all of our cases for the evening.
Yeah.
Okay.
Next up.
Next item number 10, announcements, comments, questions, and future agenda items by members of the complaint committee.
I have nothing.
Thank you all. Good night. Thank you again. Good night.
Anyone have anything for this item?
I don't. It's Member Stein.
Okay.
Nope, not me.
All right. So we can move to adjournments. Call it.
Okay. Item number 11, adjournment. I have 7:32.
Move to adjourn.
Second.
Third.
We're unanimous. Okay. Thanks, everyone.
Have a good night.
Everyone.